The application of GAR can only be initiated by the minister. A taxpayer is not allowed to self-assess on the basis that the GAR applies. And there are 3 criteria for the application of our GAR. The first is there must be a tax benefit. The second is that there must be an avoidance transaction. And the third is that there must be a misuse or abuse of one of the provisions of the taxing legislation, the regulations, Canada's treaties, or any other relevant legislation. Now, the Crown need not, in its actual reassessment or assessment, include a challenge on the basis of GAR in order to be able to plead it at trial. The theory behind that is that the tax authority will learn the facts as it goes through the process. So if there is a primary reason for the assessment, it may conclude during the course of disclosure and discovery that there are also provisions, there are also elements of the transaction which would necessitate a GAR attack. The onus is on the taxpayer to refute tax benefit and tax avoidance transaction. The onus is on the Crown to establish tax policy and misuse or abuse. And an example of this is found in the slides when you get them in the case of Lehigh Cement Limited, which was a recent judgment in which the appeal court found for the taxpayer basically on having found that the Crown had not established a discharged its burden to establish that there had been a tax policy which had been abused or misused. Now, there are 3 principles of the Canadian GAR. The first is that GAR cannot be used by the courts to fill in gaps in the Canadian taxing legislation, and this is extremely important. There is a recent case, Collins and Aikman. I've included the notes on the case at the back of the slide presentation. On September 30th, the Federal Court of Appeal basically threw out the Crown's appeal without hearing arguments from the taxpayer on the basis that if the government had intended a regime, it would have put one in place in the statute, and the court was not there to effectively fill gaps when an offensive transaction occurred. Second principle, Canadian tax law must be certain, predictable, and fair. And the third one, the GAR is not meant to prevent tax planning. It is meant to prevent events from occurring which abuse the object and spirit of the Canadian legislation. What is a tax benefit? It's a very broad definition. It covers not only reduction in tax, but reduction in amounts payable, and it also covers adjustments to different items of income. How is the tax benefit evaluated? It's evaluated against what the tax that would otherwise have been payable is, and it's evaluated against alternative transactions. An avoidance transaction. What is an avoidance transaction? It is a transaction that, but for this section, would result directly or indirectly in a tax benefit unless the transaction may reasonably be considered to have been undertaken or arranged primarily for bona fide purposes. Where a series of transactions is undertaken, if at least one transaction in the series is an avoidance transaction, then the tax benefit from the entire series may be denied. There are a number of factors to consider in determining what the primary purpose is. Doesn't have to be the only purpose, but there is a weighing exercise that goes on in the court's analysis of the economic benefits to the tax benefits. The expression non-tax purpose is broader than the business purpose, and no recharacterization based on the economics or the commercial realities of a transaction can actually be carried out in order to determine whether or not you have an avoidance transaction. You may use those things to determine whether or not there is an abuse, but not whether there is an avoidance transaction. Now, we're going to look at the series concept in Canadian law, but as I said before, you examine each transaction in the series on a standalone basis. Each must not have a tax primary purpose. If any does, then it taints the whole. And obviously, one of the big questions in Canadian law is, what is a transaction? Canadian Pacific helped with that in saying that the choice of use of a foreign currency would not be a transaction. It was an element, but not a transaction, for which there had to be a non-tax purpose. What is a series? The common law test is set out here: transactions preordained to produce a given result. However, for Canadian tax purposes, there is an expanded definition which applies in the context of GAR. And that expanded definition effectively builds on the common law definition, but incorporates a concept of transition, which is backward-looking and forward-looking, and also adds the concept of in contemplation of. And what does in contemplation of mean? Well, this is being hotly debated right now, and the Supreme Court will hear the Copthorne Holdings case this fall, and hopefully provide some clarity. But in contemplation at this point has been given an expanded meaning, so as to suggest that all the one transaction has to be is motivated by the possibility that there might be an advantage in another transaction, and those two will be part of the same series. The benefit in one will be effectively, the resulting benefit in one will be considered to be the result of the other. What is an abusive transaction? Well, the courts have gone through the process of actually designing a way in which to make the inquiry and the analysis. I've set it out for you here. It's a textual, contextual, and purposive inquiry into the object and spirit of the legislation, harking back to the Stubart decision, which I mentioned earlier. A transaction will be abusive in Canadian law if an outcome that the provisions seek to prevent is achieved, if the transaction defeats an underlying rationale of the provisions or circumvents specific provisions in a manner that frustrates the object, spirit, or purpose of our act. An abuse does not occur, however, where the provisions relied upon are used for the very purpose for which they have been included in the legislation. There. Can GAR be used to recharacterize a transaction where there's a specific anti-avoidance rule and that rule doesn't prohibit it? There are 3 cases that I refer to here. The answer is an unequivocal yes. The GAR can be used with and in supplement to the specific anti-abuse provisions. Now, when the GAR was introduced, there were a number of criticisms. I've heard the same types of criticisms mentioned over the last day or so. First of all, the major criticism from tax advisors was it was unnecessary. There was a lot of tools that were available to the tax administration to preclude abusive tax avoidance, and nothing new was needed. Secondly, it was unconstitutional and a violation of the rule of law. Thirdly, it was to give power and unfettered discretion to the Canadian Tax Administration, and that was extremely dangerous. And fourth, it was going to produce a whole lot of uncertainty that would be a serious impediment to legitimate commercial transactions.